Well, the three dissenting judgments are, in our view, the correct position of the law, and we regrettably disagree with the majority judgment delivered by the Chief Justice himself. We believe there are flaws in the judgment, which we will look at closely and then decide on the next course of action. We have not decided on anything at the moment.
Is there any further?
Well, there is a provision for review, but very rarely invoked. But we will consider that.
What did he say about the minister's letter, the Home Minister's letter?
Home Minister's letter. Well, we have challenged it from day one as being unconstitutional, ultra-virus, illegal, and unconscionable. So we still maintain that the restriction placed is wrong.
Can you explain on the review procedure if you want to go for the review?
Well, you see, I'm not exactly sure whether the review is applicable, but this is something that we will consider. Right? It has been done before in other panels where other panel decisions were reviewed, but not sure whether this is applicable on the facts of this case, but that's something to consider. All right?
The Court of Appeal decision seems to have gone beyond the Herald. So does this also uphold that?
Well, in dismissing the leave, the judgment of the Court of Appeal has been upheld, so that is the law at the moment until a court in a future day is able to revisit this and put it right. All right?
If the paper in future, following this decision,
Yes.
continues to use the word Ella,
Yes.
what sanction might they face?
Under the Act, they can be suspended or their license be revoked. Right. So those are the penalties which we face, and Father Lawrence, Andrew being the editor, will abide by the decision of the Court of Appeal. All right. Yeah.
So, the government has said that this case only applies to the Herald, but in your view, with this judgment today, does it apply to all Christians?
Well, it is not clear. It's not clear. All that the federal court did was to dismiss an appeal, an application for leave, on the grounds that the questions did not merit further consideration at appeal proper. That's all I can say. I don't want to read too much.
So whether it's going to apply to Sabah Sarawak also, it's not clear.
It's arguable. Yeah. Well, one can say it applies to Herald, but the SIB leave application was dismissed on the grounds that this Court of Appeal judgment was binding. So there you are. There's one example of the decision extending beyond Herald.
So Sabah Sarawak is not excluded.
Well, it's arguable. It's arguable. Well, the SIB case was lost on that ground, that the Court of Appeal decision also applies to educational books. All right, not just Herald. All right.